Well, thank you so much for that kind introduction, Jackson. It's a thrill to be here. My first time to Australia, certainly my first time to Bond University. I'm just blown away by how beautiful the campus is, and perhaps even more blown away to see this many faces in a classroom on a Friday night. That is, I mean, I'm going to have little voucher slips for all of you to sign to vow you're going to come to be students at my school. This is remarkable, and feeling more pressure and inspiration to make it well worth your while. I know there are a variety of things you could be doing on a Friday night rather than listening to me speak about animal law. But this is truly a labor of love for me. Coming to animal law has been very recent in my career. I come from an environmental law background, 2 decades of environmental law practice and teaching, more recently in the international side of environmental law issues, and it was through actual animal law moot court in the US that kind of got me drifting into animal law, and it's been a thrill ever since. Getting this book project together just seemed like this natural connection of these two worlds that kind of float apart from one another, and part of the impetus for the book is to really drive home the reality that they have a lot in common and they need to work together. So I want to just give you a brief sense of what I want to cover in my remarks. So just give you a sense of how the book concept came together. Then there are issues in history, politics, and law driving this notion of environmental law as the senior of these two fields, and animal law looking to advance the way environmental law did 3 decades ago. A lot of things that essentially environmental law has blazed the trail for animal law, and there's a lot of opportunities there to learn from what environmental law experienced, the challenges it faced, and how that might serve as a path for animal law. And then there's just the book is 17 chapters. This is just really just a few of the highlights of examples that I want to touch on tonight to generate some discussion. So we're in Australia, so I wanted to make some reference to the chapter in the book that does address Australia, and how there are dichotomies in terms of how animals are protected. Some animals are protected quite well, others not so much, and we certainly experience that in the US. So there are parallels there, and then also the international law dimensions of how environmental law has done so well internationally, and animal law is barely on the stage for developing an international law presence. And so the focus in my teaching and in this book is always on kind of practical outcomes. What does all this mean in the real world? How can we make something better happen? All of us have an interest in doing more to protect animals, using the law as a tool to make that happen. So there are 3 themes that I want to hit on that will be areas of ways in which animal law and environmental law can actually work together for mutually beneficial outcomes. And I always come back to food law and policy. I've taught animal law 3 times in the past 3 years, even less than 3 years. And a lot of the discussion ends up focusing on food law and policy because it's so connected to both animal and environmental law. And then climate change is just the defining issue of our time, and certainly animal law and environmental law have pieces of that dialogue and the outcomes we should be striving for with respect to climate change regulation. And then there's the information access and dissemination realities that environmental law confronted and succeeded with, and animal law is struggling with right now in the US and Australia. So those are the kind of the 3 themes that I want to focus on for collaboration opportunities. So I've already mentioned what's going on in this slide, just the idea of working with environmental law and then starting to work with animal law. It was just one thing after another that came to my attention about I'm teaching animal law and I'm working on this particular topic, and I was just getting a deja vu over and over again about this is something that environmental law has faced in the US in the 70s or 80s, at the international level, perhaps a little bit later. And it literally just evolved one lesson at a time to the point that it was a massive book project after a few weeks of thinking through it, how many different dimensions there were to this reality of environmental law being this leader that animal law could follow. And then that also led to more of the last unit of the book, which is about solutions, which is about how these two fields can work together. So the book is really doing both things, even though the title only reflects the first aspect of that, the notion of animal law following on the coattails of environmental law. There's also a big part of discussion about how the fields can work together more effectively. So one thing that struck me most about how environmental law launched into what it is today in the US, environmental law had a bit of the fringe reputation that animal law currently has in the US, and I suspect also in Australia. Environmental advocates were perceived as tree huggers and hippies, and perhaps rightfully so. They were coming from that cultural reality in the 60s, 1960s in the US. And even prior to that, environmental law was all about protecting resources, protecting trees in their own right, wilderness areas, rivers in their free and wild and natural state. And then there was this big transformation in the early 70s where environmental law all of a sudden became a movement about human health. So we had these environmental problems that were environmental at one level, water pollution, air pollution, land contamination by hazardous waste. All of these problems were environmental problems as we had seen in the past, but ultimately what caused environmental law to be launched into the field it is in the US today is linking these environmental problems to human health. So water pollution, certainly there was a very clear linkage about the quality of our drinking water. Air pollution, the quality of the air that we breathe. There was a major awareness campaign about how bad the smog was in Los Angeles, so bad that it was impairing visibility and obviously causing lots of lung-related illnesses. So that connection really was what made environmental law what it is today in the US. Many federal statutes in the 1970s, and that's the law piece of this slide. Many environmental statutes in the 1970s and 80s came out of that awareness, linking environmental problems to human health. And then all of a sudden, they became front and center political issues in Congress. All of a sudden, it wasn't just some tree hugger's agenda to do something more to protect resources. It was about protecting our livelihoods as human beings, our health. So this notion of dichotomies and anomalies is something that's covered in multiple chapters in the book, and the fundamental premise for why animal law struggles the way it does right now for the legitimacy that environmental law has enjoyed for decades is this reality that the law isn't doing animals any favors. Ultimately, the starting premise with animal law is that animals are property. To the extent that animals are property, they aren't enjoying this independent set of rights the way humans do, and that is just starts this cascade of opportunities for mistreatment across multiple areas. So certainly in the food dimension, that's a big problem. The fact that animals are property, we have in the US federal statutes that are kind of misnamed things like the Animal Welfare Act, and yet it doesn't cover agricultural animals, it doesn't cover multiple animals that are primarily used for animal experimentation, so it doesn't cover rats, mice, birds, and 95% of the animal medical experiments are conducted on these animals that are not covered by the Animal Welfare Act. Agricultural animals can benefit from the Humane Methods of Slaughter Act. So essentially, you're already going to be slaughtered well before you would naturally die, and then the Humane Methods of Slaughter Act tries to make sure that you're stunned before you die. And it's very poorly enforced, and lots of undercover footage of slaughterhouses reveal that the act does not have any teeth, if you will, in terms of being enforced effectively. So then you've got other realities about some animals have it quite good in the US. Companion animals do have a higher level of protection under the law than agricultural animals and animals for medical experimentation. But even so, there's chapter 10 addresses the existing reality about companion animals. General rule in about 45 of the 50 states in the US is that if your companion animal is killed, the replacement value of that animal is the market value. what you paid for it or what it would be worth for sale. There's nothing to build in that kind of, this is a member of your family. All of that emotional attachment damage level opportunity is only there in a few US states. So ultimately, even though companion animals have much better status under the law than many other animals, they still are not in the same domain as the way humans are protected, and the loss of a companion animal typically doesn't generate much of recovery for that reason. Likewise, there's a huge problem, climate change, a big piece of what's causing this problem, but a huge problem with invasive species. And these are not just animals, there's also invasive plants. But the approach typically to invasive species is exterminate. So basically an invasive species is a, what we'll use the animal context, is a particular animal that has somehow migrated to an ecosystem where it doesn't belong. And ultimately, it's in that ecosystem, it wreaks havoc, and in many ways becomes a predator and knocks out top predators in that ecosystem, disrupts the ecosystem balance entirely. And then the only response is you just got to exterminate it. You have to go in there and get rid of it so you can restore the ecosystem balance. But the reality is that these animals are innocent. In many instances, invasive species are just introduced by humans who didn't want that pet anymore. So we have a major problem in the Florida Everglades, for instance. There were some private pet owners that just released Burmese pythons into the Everglades, and now they're eating alligators for lunch. It's wreaking havoc on the ecosystem. We're talking 6 feet, 200-pound snakes in an ecosystem that never anticipated that kind of a predator. And but you can't blame the snake. The snake is just living in the place where it just got transplanted to. So there's now a movement to have more humane methods of removal of these invasive species. Even though they are predators in this new foreign ecosystem, they should not be slaughtered as pests. They should be humanely removed and allowed to thrive where they belong. So there's this reality about the law is not treating these different types of animals the same. And ultimately, there are cultural aspects to that reality as well. So we see it in both the US and in Australia here, with the treatment of kangaroos versus whales in Australia. There's a chapter in the book devoted to this. And coming from the US, we like kangaroos. We think they're iconic creatures. We think they're, you know, right up there with the polar bear and the sea turtle. You know, they're really, and we hold them in very high esteem, and from what I understand, they're more like mosquitoes in Australia. They're not given a whole lot of respect. There are government programs that essentially hired assassins are appointed to eliminate them, and literally to the point that some have been pushed to extinction in certain areas of the country because of this cultural attitude that they're just a pain. We don't want them. And of course, whales, on the other hand, are exalted. I mean, Australia is well known for its passion for whale conservation. There was a major case in the International Court of Justice on this recently. And it's hard to argue with, sure, we should be affording a lot of protection to whales. Everybody likes whales. They're critical components of the marine ecosystem, but that shouldn't imply that therefore we get to hate kangaroos. There should be a baseline of love and respect for all members of the ecosystem, whether you're an animal or plant or whatever. And so, of course, this is a reality in the US with our treatment of agricultural animals versus companion animals. Companion animals, some of them get treated better than the humans in the household. They eat better for sure. And with respect to agricultural animals, could not have less respect in the US than the way agricultural animals are treated. It's shocking. So, a response to that disparity is really to think from an environmental mindset, that when we think about ecosystems, ecosystems are about everything. You know, you've got the plants, you've got the animals, you've got the other resources, the land, the water. Having some kind of intrinsic value-based approach to ecosystem management will be a way to kind of level that playing field for animals. Every animal has an intrinsic value. So a way of thinking about this is, in the past 20 years, trees and coastal wetlands have developed this heightened sense of importance because of their ecosystem service value. So in the era of climate change, we're all about protecting trees and even adding trees to the ecosystem because they're so good at taking out carbon from the atmosphere. Likewise, coastal wetlands. They used to be just that ugly thing that was in the way of that next strip mall or the next development. Just fill those coastal wetlands. We don't want them. We want to prosper and grow economically. And now coastal wetlands are sacred. They're understood as being aquifer recharge areas and buffers for coastal storm surge and migratory waterfowl stopovers. So the reality is that these kinds of intrinsic ecosystem value judgments that we do with resources can equally be applied to animals. Animals have a role in the ecosystem regardless of how cute or cuddly, large or small they are, and it's strange that we apply that kind of ecosystem logic to plants and wetlands and trees, but we don't with animals. It doesn't really make any sense at all. At the international level, as I mentioned, the environmental law in the US is quite sophisticated, been around much longer than animal law. Likewise, at the international level, international environmental law has just exploded in the past 3 decades. I teach international environmental law. It's my heaviest casebook, and the field is only about 40 years old. So international environmental law has been a field that animal law could learn a lot from, in the sense that there are certain baselines of protection that need to be afforded to all animals, and we don't have that. And global animal law is a chapter in the book, and it's essentially an aspirational chapter, because there's virtually nothing right now in the legal on the books for international animal law. The only things we do have are borrowed from international environmental law. We have international treaties protecting whales. We have international treaties protecting, regulating trade in endangered species. So these are animal related, but they're environmental treaties. We need something that is entirely separate, that's focused on animals exclusively, welfare-based, rights-based provisions that are related to the protection of animals that globally we can agree, either affirmative protections or agreements that these are things we should not do to animals. So I'll give you an example. I just gave lectures at University of Wollongong and University of Western Australia on shark finning. Live shark finning is a practice that is unfortunately alive and well in the world, and it's just utterly gruesome. It's hard to imagine that there's anyone who would agree that live shark finning is appropriate, an appropriate way to treat an animal. Essentially, the shark is brought on board a ship, it's suffocated, the fins are lopped off while it's still breathing and suffering, and it's thrown back into the ocean to drown or be consumed defenseless by predators within minutes. And this is something that's happening to 75 million sharks a year. So there are many practices like this, and we don't have to look far. Our food production system, same thing, slaughterhouse practices. To the extent that animals are suffering far more than necessary in a slaughterhouse, there can be a declaration of a variety of these principles that these practices are intolerable. And as a global community, we can agree on these things. And that could be tomorrow's treaty, tomorrow used loosely, of course. In decades into the future, if you have a declaration of aspirations, that is the way international law works. That could be the treaty that comes up on the coattails of that declaration. So there are certainly ways in which international animal law needs to evolve by at least starting with that baseline. Sure, there are cross-cultural distinctions. The cow is sacred in India. The dog and cat are sacred in the US. There are all kinds of cross-cultural distinctions about valuing animals to a greater or lesser degree, but there's lots of common ground at a baseline level to get something addressing animal protection. And there's certainly international trade law as well. That's had a recent, very important case regarding using public morality as an exception to how international trade can be conducted. So there was an objection that the EU lodged against Canada. It's saying, we don't like the way you're harvesting your seals. You abuse them, and we're not going to trade with you in that product because of the way you harvest your seals. And the International Trade Court, World Trade Organization, dispute resolution body said that's a legitimate objection in terms of lodging an exception to what a trade partner is doing. The case didn't ultimately succeed for other reasons, but that was the first time that animal welfare concerns were considered a legitimate public morality exception that can be used in international trade law. So that was a big success, and there are opportunities now to use that in other cases. So we've talked about how the environmental law has had this evolution that's been quite effective. So that middle step all the way back in the 70s, pollution control laws, the human health focus. Now environmental laws in this really sophisticated era of post-climate change, environmental rights are now evolving in the environmental law arena. It's a merger of environmental protection and human rights, and it's helping environmental law advance. It's morphing into a new way of protecting the environment and acknowledging that environmental harm has serious, life-threatening consequences for humans. We're not just talking about lung ailments and bad water. We're talking about literally you're losing your homeland. Sea level rise is going to displace you, and you're going to have to be relocated as an island nation to a whole nother country. Lots of human rights implications flowing from where we are with climate change impacts and how environmental law is responding or trying to respond. With animal law, we're not seeing that. So we're still trapped in that middle stage. I'm sure Australia has many of the first block, as the US does. All 50 states recognize anti-cruelty, and that's a very bare minimum baseline for how we should be protecting animals. Basically, you can't abjectly abuse or neglect animals, or if you're found doing it, which is very unlikely. These statutes are very hard to enforce, but basically the only thing we're providing is abject cruelty will not be tolerated. You can't throw your pets across the room. You can't leave them out in winter attached to a chain so they freeze to death. These are the things that would be subject to prosecution, but we can do far better than that. So federal and international protections just aren't quite there yet. They're really still evolving. And what's interesting, though, is that the movement is jumping ahead to this animal rights view, which is very promising and needs to be pursued, even though that middle block in the chain has not been fully explored and realized. In the US and in Australia, as I understand, there are cases now being brought on a kind of personhood paradigm. In the US, there are cases where chimps that are being held in captivity, an argument is being lodged through our what's known as habeas corpus, action to have a person released from confinement. And yet this is a chimp, it's not a person. And so arguments are being made that the chimps should be afforded this minimum level of human rights-like protection, the freedom from torture, freedom from confinement, and so they cannot obviously dress up in suits and go to court the next day and take on human-like qualities, but they're placed in a sanctuary where they can live according to their natural instincts, not chained to someone's basement against their will. So that's a promising movement, and it's just starting, and that's really where animal law needs to ultimately get, and we're a long way from getting there, but it's nice to see these ambitious efforts to start that progression. So with climate change, this is the big message that I want to start thinking about for solutions. Many people think climate change is all about coal-fired power plants and transportation, our cars, and that's true. You know, when we think about that pie graph for what's causing climate change, there is a big contribution from our electricity and heat generation and our transportation modes. But if you look at about a third of this pie, it's really related to our food system. Agriculture, land use change, and forestry. Throughout the world, we've got forests that are being leveled so that cattle ranches can go in there to feed our need for beef. And so there's a whole lot of what we're doing to the earth that's causing climate change, getting these greenhouse gas emissions into the atmosphere, that's related to animals and food. And transportation is not just about our drive to the office. Transportation is about how we're transporting our food to the market and to our dinner tables. So easily 1/3, many estimates put it higher, 1/3 of why we've got climate change running away from us is related to animals and food. So CAFOs is the acronym for Concentrated Animal Feeding Operations, and this is a big driver of climate change as well. Most of the time when we hear about climate change, it's about carbon dioxide, and yes, that's the leading greenhouse gas. But methane is a significant greenhouse gas. Estimates range from about 20 to 50 times more potent than carbon dioxide as a greenhouse gas. So you don't need as much methane to have a very significant impact on climate change. And that's what's coming out of these agricultural operations. Significant amounts of methane, especially when they're literally the size of a small city, when you talk about how much livestock is housed in these massive facilities. So there's certainly an aspect of getting information to the public about this reality. What's amazing to me is I was in the environmental law movement for decades, and this information about how our food is produced was not something that was on my radar screen until about 5 years ago, which is crazy when you think about how in the dark the rest of the US is, if I wasn't even aware of how our food is produced in terms of the impacts to livestock. So there was a great information campaign going on in environmental law. It got all of the information out to the public. Pollution records were public information. They were supposed to, not supposed to be, they were required to be available to everybody. If you're discharging water pollution or air pollution, you had to report that information. No one had to go to court to get it. It was available to everybody. Animal law needs that kind of guidance and paradigm. So right now we have things that are called ag-gag laws that are preventing that access to information so that we can tell the public about the horrors of what's going on in these concentrated feeding operations. And that's a work in progress. The animal law movement has been very aggressive about trying to get that information. Many of those efforts have found people subject to prosecution for going undercover and trying to get the information. So there are really three big parts of how these feeding operations are causing climate change. And well, not just climate change, how they are being harmful in general. Animal welfare issues in these facilities are enough to make most people want to change their eating habits, but there are so many things going on beyond those mistreatment realities for animals with respect to public health. How the meat is being produced with antibiotics and how much of a health impact a meat-based diet is having is another huge example about trying to transition away from the meat-based diet that is represented in these CAFOs. And just recently, environmental issues have come more into the public awareness. There's a great documentary called Cowspiracy about this reality that I highly recommend, and how much methane is coming out of these facilities contributing to climate change. So this is the human face of this reality. Famous Australian philanthropist Philip Wollen has this quote that when we engage in this widespread meat-based diet, we're not only harming animals, we're not only harming the resources in our planet, we are actually harming other humans. We are actually advancing world hunger, we're advancing world water shortage because of these choices in our food system. And it's not just beef. You know, I've highlighted milk, cheese, and eggs. I mean, many vegetarians are consuming milk, cheese, and eggs. Look how damaging that is when we talk about environmental degradation, when we talk about world hunger and access to water. So again, a lot of these issues come down to our food choices. And it is about advocacy with respect to food choices. So when I teach animal law, I don't say, you're in this class, you got to be a vegetarian or a vegan by next week. I say, I want you to have the information so that you can make that choice. I never push the issue. I tell them, I didn't become a vegetarian until 5 years ago, which is insane. I'm embarrassed to admit it. When I was inviting faculty candidates to come to my school to interview for a faculty position, I took them to a steakhouse without even asking them their food preferences. And the poor guy ended up eating shrimp because there's nothing on the menu to accommodate his food preferences. I mean, this was something I was doing less than a decade ago. So a lot of it is we just do what we do because people around us are doing it. There's no need to question it because we don't have information to question it, why it's got so many impacts that we wouldn't want to impose if we were being mindful. Sure, there are reasons not to go vegetarian or vegan tomorrow, and a lot of them are cultural and perhaps religious based, but ultimately most people don't have that information such that they're making an informed choice. They just kind of go blindly through their lives and eat what's in front of them or eat what's being served for whatever reason without thinking about it, without thinking about public health, without thinking about animal welfare, without thinking about the environment. So this is something environmental law and animal law can do together. Climate change, food advocacy, access to information to the public. This is something that is a powerful opportunity for synergy. So I want to stop there and make sure we've got plenty of time to hear some valuable commentary.